This is Lee Marvin of Marvin Law Office. I'm here today to talk about a recent immigration update as it pertains to public charges. There was a proposed rule that was released on September 22nd of this year, announcing the changes for the inadmissibility standards for public charge grounds. It was a 447-page proposal, so it's extremely detailed, extremely complicated, and pretty difficult to understand unless somebody summarizes certain things for you. The most important thing to remember is that this is a proposed rule, does not exist yet. It probably won't exist for another year or more. We're right now within the 60-day public comment period. At the end of the 60-day period, it'll close. Department of Homeland Security will then review the comments. They will basically release their response to the major concerns that people had in those comments. And then they will make some revisions to the policy if they think it is needed, and then they will announce a final rule. So again, this will be probably a year or more from now. With the amount of litigation and the issues and history of what's been happening in the last year or two for immigration, I would expect that there's going to be a lot of public comment, and this is going to make this proposed process take even longer, which is a good thing because there's a lot of significant repercussions to this proposal. Who does this apply to? This applies to immigrants seeking certain types of visas, mostly green cards. H-1B visas are another big type of visa. Basically, there's certain visas that require the applicant to show financial stability to the government. That financial stability, basically you need to show the government that you're not going to become a public charge or dependent on the government for assistance for basically moving forward with their lives. So those type of applicants have to show that they meet the 125% of the poverty line level, which, for example, for two people, spouse and U.S. citizen, they would have to make basically $21,000 per year or more to show that they meet those financial requirements. There are people, and it's very common, and most of my clients are required to use this, which is a separate co-sponsor to help them meet that requirement. A co-sponsor is a family member, a friend, somebody at church or school. Anyone who is a U.S. citizen or a legal permanent resident can be a co-sponsor to show that they have resources that the government can come to if the person applying for the process cannot meet their financial burdens with the government, and if they are to go on public assistance. That is very important because those individuals can move forward with their process with that assistance from their friends or family. This proposal applies to certain types of public benefits. Not all public benefits are included in this. Basically, the most common, food stamps, federal housing benefits, which are Section 8, rental assistance, non-emergency Medicaid benefits. So things that the government gives you cash money for, those are things that if you receive, it's going to create issues. In the proposal, they talk about when that will apply and how many years in the past you have to show that you haven't taken those benefits. That all is within the proposal, and that's all very technical right now, and I don't want to go into that. But there will be a very, very clear explanation of when that will be applied. But right now, again, this is a proposal, so don't think too much about it right now. The benefits that this does not apply to or is not expected to apply to would be emergency medical care, short-term non-cash disaster relief, immunizations or communicable disease issues. So basically the government wants people to go to the doctor or to the public services if you have a disease that might endanger general society. So that is something that this would not apply to. Programs like soup kitchens, crisis counseling, different types of treatment like that, certain HUD, housing and urban development programs, Head Start, does not apply to Head Start, does not apply to school breakfast and lunch programs. And also, in that vein, it's important to know that this applies to people who are not citizens. So if you have children that are citizens, all the benefits that exist in the United States that they qualify for, they can obtain without affecting how this might impact their parents or other family members. So U.S. citizens, U.S. citizen children don't have to worry about any of this stuff, okay? The most disturbing part of this proposal is not the public charge grounds. It's how the government will determine who is likely to become a public charge in the future. There's a list of 15 different things that they look at that are disturbing because there's a lot of discretion that is open to the DHS personnel in making the determination. For example, education levels, age levels, financial debt, credit scores, English ability, and whether you have any medical conditions that would impact your ability to work or go to school. That's just a taste of what's to come. Stay tuned in the future for updates. We will give you updates as we come, but you're always welcome to contact our office. Look for us on Facebook at Marvin Law Office. Also, our number here in Grand Rapids is 616-450-2981. Please call us with questions and have a very nice day.